Supreme Court of Canada, case study number 2, Cooper v. Hobart. This case was decided in 2001. Cooper is a leading case on duty of care in Canada. The facts in Cooper were: an investor, Cooper, sued the BC Registrar of Mortgage Brokers on authority established under a statute for negligence to himself and other investors. Cooper had lost a significant amount of money because his mortgage broker, Iran, had been using investors' money for unauthorized purposes. Cooper was an appeal from the BC Court of Appeal. In the BC Supreme Court, a cause of action in negligence was found, and the plaintiffs should be permitted to bring a class action. The BC Court of Appeal reversed the trial judge's decision on appeal, holding that the plaintiffs' pleadings did not disclose a cause of action against the registrar. The main issue in Cooper was whether the registrar owed a duty of care to the investing public. Was there a duty on the part of the registrar to oversee the investment activities of its registered brokers under the Mortgage Brokers Act? This was a novel duty of care situation, as there was no existing recognized category of duty of care between investors and such a registrar. The appellant's arguments were: 1, the registrar should have acted earlier to suspend Iran or warn them of Iran's breaches of the Act's requirements, and 2, their losses are traceable to the registrar's failure to act more promptly. Cooper claimed that the registrar of mortgage brokers should have suspended Iran's license as soon as it found out that Iran was violating the Mortgage Brokers Act, and not waited as long as it did before doing so, costing many investors. As a result of the slow investigation, Cooper claims he and other investors lost more money than they otherwise would have. He applied to have the action certified as a class proceeding. In summary, the respondents' arguments denied that the registrar owed a duty of care to the plaintiff and the other Iran lenders. The acts and omissions alleged against the registrar were matters of policy and were not operational matters. The court dismissed the appeal, holding that even though the registrar might have foreseen investors' losses,
there was insufficient proximity between the registrar and the investors to ground a prima facie duty of care. The statute cannot be construed to impose a duty of care on the registrar specific to investments with mortgage brokers. Such a duty would no doubt come at the expense of other important interests, of the efficiency, and finally at the expense of public confidence in the system as a whole.
Cooper's legal legacy went beyond merely stating that Mortgage Brokers Act did not impose a duty of care on the registrar to investors with mortgage brokers regulated by the Act. It interpreted long-standing law regarding the two-stage test for determining a duty of care under negligence law in Canada. Although Cooper considered the categories of foreseeability, proximity, and policy, and they all feature in its analysis, the decision's approach is generally reserved for novel cases not falling within an existing duty of care.